Hey everybody. Earlier today I said that YNW Melly's attorneys had cited to non-existent law, and I want to give you an example. So this is from the motion for reconsideration of the denial of bond. And we're not going to get into the nitty-gritty, like the fact that just the 5 isn't bold, or that these two entire paragraphs are copy and pasted. You know, we don't need to get into any of that. The formatting, the empty footnote, this is not going to be another 2-hour or 4-hour video. We're just going to cut right to the chase. Right here. Florida Statute Section 907041 B4 precludes the state from using a delinquency adjudication to satisfy its burden of proving a prior conviction for a dangerous crime under 907041 4B. And this is actually a cut and paste from a case from 1998. I'll scroll up and show you that. 99, excuse me. So use Paul versus Jenny. It was actually cited in the in Melly's motion. Section 907041 4B 4.B precludes the state from using a delinquency adjudication to satisfy its burden of proving a prior conviction for a dangerous crime under 907041 4B 4.B. Now, I need to show you that statute. This is the current version of 907041. You'll notice that, I'm sorry, I should have had this in the right spot. This is 907041 4B. There's not another 4.B. And you'll notice if you go Paul versus Jenny, remember this is a cut and paste of this part right here. They deleted the 4.B part. This is what it says in the original. So let me just show you that original again. You'll see here it says 4B 4.B, 4B 4.B. And again, this statute, or this case is from 1999, so it's an older version of the law. But you'll see here, there is only a 4B. There's not below this, 1, 2, 3, 4, and then there would be A, B. So none of that is here. It's just, there's only a 4B. But you'll see what 4B here in the current version says is it's about crimes occurring at schools. The person charged with a crime under one of these sections alleged to have been committed at or against a school or against a student while they are at school. The court has to consider certain things. So that's all that's saying, and it's not 4.B, it's just before. I'll show you the older version of the statute in just 1 second. Lost my spot there. It is right here. There we go. So this is the prior version of the statute. You'll see this is the one that was in effect when that case was decided in 99. This is section 4. This is B. 4 point, I already have a color there. 4.B. It's referring to this specific section. It is not referring to this section. But you'll also notice that they deleted, again, I said this before, they deleted the 4.B when they cut and pasted into the motion. So this is not the right law. There is a 4.B, but it doesn't have anything to do with precluding the state from using a delinquency adjudication to satisfy its burden of proving a prior conviction. It has nothing to do with that. Again, it has to do with crimes committed at school. It has nothing to do with the topic at hand. This is also a cut and paste. I can show you that real quick. Now look at situations. Yeah, it's this part right here. Oh, this appears to be a question of first impression. courts have found in analogous situations that a juvenile delinquency adjudication is not a conviction. It's just a direct quote. It's the same thing. I believe there are a few more examples of the 4B thing. Let me see if I can find some for you. Oh yeah, this is actually an even better example. Here we go. This is kind of the same problem as we had in the previous example. This is the same section. You'll see 907.041 4B, but this is 4.A to C. Go into the current version. Again, there's nothing there. I mean, there's of course a 4B, but there's not the 4.B after that. Again, we have the old law here. We have section 4. That is pretrial detention. Scroll down, you get to 4B. And then you go 1, 2, 3, 4. This is section 4. And then A, B, and C. That is what we were talking about here. Or that is being cited. And again, this is the law. It doesn't give the exact date, but it says that this section has been updated. There is an updated version. If I click on that, it'll take me to the current law. So it's a citation to a law that doesn't exist. And you're supposed to cite to law that is real, not the law that isn't real. You know, in theory anyway. Like ideally, you'd be citing to real law.